Yes.
My lord, my ladies, three matters of housekeeping, if I may, very brief. The first is, it was remiss of me not to introduce everybody, given we have one newcomer to the panel. I appear, as of course the court knows by now, for the Republic of South Africa, but with my learned friend, Ms. Hart, who wasn't here before Mrs. Wells being unavailable for the restored hearing. The court has heard from my learned friend on behalf of the interveners, and my learned friend Mr. Hoffmeyer, assisted by Mr. Miles and Miss Larthy, appear for Argentum.
Thank you.
It is also remiss of me not to have asked the court whether the court would like to be provided with the live note streaming that we have. So the court may have noticed that we all have the benefit of live note as well as the transcript coming every evening. If the court would like that to be made available, we will endeavour to have that up and running.
I have it. It seems I have been uniquely privileged in that respect.
Well, speaking for myself, Mr. Smith, I'm happy with the transcripts. Live note can be a boon, but in a case like this, I'm not sure it adds much.
I agree. Thank you.
I'm grateful. And thirdly was just, if we may, to inquire about timing. Mr. Hoffmeyer and I have discussed timing, indeed all three of us have. Our understanding from what my Lord Justice Popplewell said is that we now have 3 days rather than 2.5, but we just wanted to make sure that was accurate and we weren't having one, and then a half.
Yes.
It's 3. In which case, the suggestion is we will stick broadly to the timings that we had already indicated to court, but the extra sort of half a day will be distributed between my learned friends and myself, probably 1 hour, and part for the interveners if they
All right, we're not encouraging you to take 3 days.
So, my Lord, I was going to come back to the point about the applicability of the Brussels Convention in response to my Lord's point, and whether that leaves, as it were, Section 10.4 doing all the lifting. And the answer on reflection is probably yes, but with the assistance of the Convention. So if we are in a case where a salvage claim is asserted against a cargo or vessel owned by a state party to the Brussels Convention, then, as my Lord is aware, Section 10.6 provides that Sections 3 to 5 do not apply, which is why the provisions related to commercial contracts do not apply. But nonetheless, we would then be in a position that 10.4 did apply, assisted as, if I can put it that way, as necessary by the provisions of the Convention.
But 10.4 must mean what it means, mustn't it? It can't mean something different in the case of a state cargo owner who is a party to the Convention from what it means in relation to a state cargo owner who's not.
Well, my Lord, only in this respect, that with no Section 3 confirming that there would be no immunity in respect of a contract, one might have to look at the Convention to see what the position was in respect of a contract. But I suspect one wouldn't have to, because if one is looking at a claim in personam, one is going to look at Section 10.4b, and if one is looking at a claim in rem, one is going to look at 10.4a.
Right.
But my Lord, that would depend on how the claim in personam arose. And of course, the point I had made is if it's a claim in personam on a contract, you look at Section 3, and my Lord rightly pointed out, not if it's a Brussels Convention case. In the Brussels Convention case, the Convention itself we would suggest give the answers that would otherwise be in Section 3.
That's the last.
Well, my Lord,
it's the last thing that I'm having difficulty with.
If we turn up the Convention, which
yes.
is at tab 50 of, it may not yet be in the court's bundles, tab 50 of the original authorities bundle, page 971.
Yes, mine was added this morning, although I had looked at it elsewhere. I don't know whether
I hope all
my sisters have in volume 3 of the original authorities bundle. Until this morning, mine stopped at tab 48.
Well, mine were provided this morning, but I haven't yet put them in the bundle.
Oh, look. I've got mine, thank you.
I'm grateful. So, 971, we have Article 1, seagoing vessels owned or operated by states, cargoes owned by them, and cargoes and passengers carried on government vessels, and the states owning and operating such vessels or owning such cargoes are subject in respect of claims relating to the operation of such vessels or the carriage of such cargoes to the same rules of liability and the same obligations as those applicable to private vessels, cargoes and equipment. So that essentially confirms that the liability will still be there. Article 2, for the enforcement of such liabilities and obligations, there shall be the same rules concerning the jurisdiction of tribunals, same legal actions and the same procedures as in the case of privately owned merchant vessels and cargoes. So that provides for the jurisdiction rules to be the same. Article 3, the first paragraph deals with ships, but if I can ask the court to look at paragraph 3, state-owned cargoes carried on board merchant vessels for governmental and non-commercial purposes shall not be subject to seizure, arrest, attachment or detention by any legal process nor to judicial proceedings in rem. So there's a complete exclusion of, amongst other things, in rem actions. Nevertheless, actions in respect of collisions and accidents of navigation, assistance and salvage and general average, which are the same three categories of claims as listed in paragraph 1, relating to such cargo may be brought before the tribunal having jurisdiction under Article 2. And in our submission, the correct construction of that provision is that it allows in personam jurisdiction before the courts having jurisdiction under Article 2, still subject to the fact that there is no in rem jurisdiction. My learned friend says the opposite. He says that essentially the second paragraph.
His case is that salvage and other identified claims are completely carved out of immunity altogether for any kind of proceedings.
But were that the case in our respectful submission, the first paragraph of paragraph 3 would be OTOs in this respect, because that is essentially the list of claims that are capable of being made against cargo, certainly in rem. So as we've already looked at, certainly under English law, the only claim you can pursue against cargo in rem is a salvage claim. And certainly, therefore, looking at this, you would give with one hand and immediately take it away with the other hand. You would grant immunity from the in rem claim in the first paragraph and immediately take it away in the second paragraph if the learned friend is right. So we would suggest the proper reading of this is that the courts that would have in personam jurisdiction over the state under Article 2 have that jurisdiction under the paragraph beginning nevertheless.
Well, you say that the only way in which you can bring an in rem claim against cargo is a salvage claim, but that's maybe true in this jurisdiction. What about other parties to the Brussels Convention? You may have a party to the Brussels Convention that doesn't operate under a common law jurisdiction, but a Roman Dutch or a different type of jurisdiction where there may be very different rules. We simply don't know.
My lady, I can't take the matter any further in that respect than in respect of English law in the context of this section, considering it in the context of section 10.6 of the State Immunity Act.
Well, I follow that, Mr. Smith, but I think it's a fairly dangerous assumption to make that your argument that it's all OTAs because you're giving with one hand and taking away with another assumes that all other states under the Brussels Convention confine in rem proceedings over cargo claims to salvage, and that may not be right.
My lady, I see the force in that, but nonetheless, the prior point that I made,
yes,
that if one looks at the list of claims there,
yes,
whichever jurisdiction one is operating in, those are, we would respectfully suggest, in any jurisdiction, classic statements of the claims that may be made against cargo. So, in respect for collision, accidents and navigation, assistance and salvage, general average, and actions on the contract relating to such cargo. I'm not going to say I can say for certain that there would never be any other claim against cargo, but it's, in our respectful submission, conceptually difficult to think of other claims against cargo. And therefore, you would still be giving the immunity in the first paragraph and taking it away in the second. But I don't think either party has been able to identify any authority in this jurisdiction or anywhere else that casts any light on the provision that I think it's fair to say the judge said he found difficult and didn't get much assistance from. But my lord, to go back to the point I was debating with my lord, nonetheless what it shows is that the liability under Article 1 is preserved, and then the immunity is there in respect to the in personam claim, in respect to the in rem claim, but on any basis not in respect to the in personam claim. And therefore that would be the equivalent of section 3 if one were looking at a contract claim. So that would be the route by which one said if you had a claim that you wish to pursue in personam that arose out of a contract, that you got to the applicability of section 10.4.
case, you wouldn't have a claim for salvage under 10.4b in the case of a wreck, because the vessel wouldn't be in use.
You might have a claim for salvage, but the immunity issues, you would have
But you'd be immune, the
Yes.
state would be immune from a claim.
Yes. So the claimant would have a claim for salvage, but the state would be immune.
While we've got this, what we do get out of it is that Article 3.3, which is dealing with state-owned cargoes which aren't on state-owned or operated vessels, doesn't actually identify them by reference to the use of the vessel. It uses the expression on-board merchant vessels. And it's the draftsman of the 1978 Act who, whatever the proper interpretation of this, has used use of the vessel in place of merchant vessel.
Commercial use of the vessel.
Well, merchant vessel under the convention.
Indeed, but in the 78 Act we have commercial use of the vessel in place of merchant.
Use of the vessel for commercial purposes, yes.
My Lord, exactly. And we will come on in a different context to look at the 3 international conventions on liens in due course and see the same phrase repeated there. But our submission will be that the phrase merchant vessel used in some of the conventions is synonymous to commercial vessel. In other words, one being used for the generation of profit for the owners.
I was drawing attention to it more for the assistance it might give us on whose use of the vessel in section 10 is being referred to. The Master of the Rolls floated the idea that in the case of salvage, it might be sufficient to say that the vessel was being used by the salvor. When he asked you why it has to be used by the ship owner, your answer, which I have to say I wasn't terribly convinced by, was because we were concerned with state immunity. But we're here looking at immunity of the cargo owning state by reference to use of the vessel by somebody else. But I can see that the argument may gain more force if you say, well, what the draftsman of the 78 Act was doing was adapting what in the convention was merchant vessels and using the language of use of the vessel for commercial purposes, which must really mean the use by the owner or the operator.
My Lord, yes. Following on from that, if I can just pick up while we're on the subject, 2 points. Firstly, I think what the Master of the Rolls put to me was relating to the use of the cargo rather than the use of the ship. And I think what he put to me was that you might have to look at whether the salvor was using the cargo for the purposes of essentially earning his salvage by salving it. But I see my Lord's point, and I think it was in that context that I said, but you're looking at a claim to immunity by the owner of the cargo, and one needs to compare apples with apples. And the other point relating to merchant ship or ship in commercial use, there was a short discussion last time about the use of the words intended for use and why they were there in relation to the ship. And I'll mention it now because it's a convenient moment. I've already made my submissions about why in relation to cargo it says use when cargo is hardly ever in use or intended use. They're disjunctive. Then I think my Lady Justice Andrews put the point about, well, what about the ship? Why do you have to have use or intended use? Because the ship is always in use. And actually, I was going to give an example, which is actually the Premier Congreso del Partido, which was arrested immediately on delivery, so she wasn't in use yet. So the intended use there, that is an example of where one might look at the intended use of a ship. So she was still at Sunderland and fresh off the blocks from the yard that had built her when she was arrested. So, my Lord, I've taken that slightly out of turn, but not very much, because the next point I was going to make in my thumbnail sketch as to where we were on immunity was that in our submission we would in any event be immune if one was looking at this purely in terms of the Brussels Convention. And I've taken the court to the
Sorry, whilst we've got the Brussels Convention open, can I just ask you about something else that's just puzzling me slightly? Article 3.1 is what preserves or confers immunity for state-owned or operated vessels or cargoes on those vessels. And in para 1, it's got some particular types of craft, another craft owned or operated by a state and used at the time the cause of action arises exclusively on governmental and non-commercial commercial service. And that is what is carved out, that stage as having preserved immunity in relation to seizure, attachment or detention by legal process and judicial proceedings in rem. If one goes to the protocol and we look at the first paragraph of the protocol, which is at, I'm sorry, I've taken this out of separately from the bundle.
976.
Right. And it says, doubts having arisen as to whether and how far the words operated by a state in Article 3 of the Convention apply or might be interpreted as applying to vessels chartered by a state, either for a given period or by voyage. Following declaration is made in order to dispel these doubts. Vessels chartered by states either for a given time or by voyage, provided they are exclusively used on governmental and non-commercial service, and the cargoes carried by such vessels shall not be subject to seizure, attachment or detention of any kind. Immunity shan't prejudicially affect any other rights. That all makes perfectly good sense if what it's making clear is that what they mean by operated by a state includes voyage or time chartered ships chartered in for state sovereign purposes. But what was puzzling me slightly is that the way the protocol works is that only applies to immunity from seizure, attachment or detention. It doesn't, as does Article 3.1 itself, make any reference to judicial proceedings in rem. Which might suggest that the parties to the protocol had now got a slightly different view of what the proper scope was of the immunity, and that it really is directed at what is in section 13 of the 78 Act. That's to say detention and seizure, and not really directed at proceedings in rem beyond that.
Say, first point, say that section 13 does specifically refer to proceedings in rem, seeking to arrest the vessel and move forward with the in rem procedure. But
Sorry, I can't hear you.
Sorry,
Mr. Smith.
sorry, my lady.
Voice
Say
is
that
dropping.
section 13 does include proceedings in rem when they proceed to arrest of the reeds.
Yes, because that's the enforcement jurisdiction.
Enforcement, that's all I was going to say.
This, if one's putting it in terms of adjudicatory immunity and enforcement immunity, that paragraph of the protocol seems to limit it to enforcement immunity. But where that goes, I don't know, but it's slightly puzzling.
Well, my lord, I'm reluctant to view it through English-coloured spectacles, but it may well be because the unavailability of the action in rem, certainly under English rules in relation to action in rem, in relation to the voyage or time-chartered vessel once the voyage or time charter had come to an end. In other words, it was simply not necessary. But apart from that possibility, I'm afraid I can't assist my lord any further other than to say that that issue does not arise in respect of paragraph 3 of Article 3. Because we're talking about vessels rather than cargoes.
All right, thank you.
So our submission, drawing those strands together from this morning, that short debate this afternoon, is that the learned judge both misconstrued the Act, in other words, section 10.4, and misapplied the restrictive theory, as we've set out in grounds 1 to 4 of our notice of appeal, because it appears he wanted to achieve the result which he thought was not surprising or would not be unfair or unexpected, but overlooking with respect the fact that a successful claim to immunity always leaves the claimant with no remedy in the court in which immunity is invoked, but does not leave the claimant with no remedy at all. His legal rights remain intact and remain available. For example, quoting from Lord Sumption in Bencarbush at page 373, for example, to be adjudicated upon in the courts of the state itself. And that's the point my learned friend was making this morning. But even if...
Subject to limitation.
Subject to limitation, indeed, my lady, but in that context, it is then the limitation provision that is barring the remedy rather than the invocation of state immunity, or perhaps the combination of the two. And again, the same can be said in any case where a defendant invokes limitation. They are getting, in one sense, a windfall, but they're getting a windfall that is there for policy reasons, which is why the limitation provision is there.
subject, of course, in both cases, that the right is not extinguished, and therefore, if it can be put forward by way of a defence to a claim, it doesn't prevent it being adjudicated upon by the court. Am I right in thinking you would accept that if you were to bring a claim in the courts asserting your ownership, and the salvors were to say that that ownership is subject to a maritime lien for salvage, the court would be able to determine the amount of salvage, and your immunity would not attach to it because the proceedings had been commenced by you. Do you accept that or not?
There's a lot of stages in that question, my lord, and the first stage was assume the existence of a maritime lien, which of course, as I've said, I'll be coming on to deal with later, that we dispute that. But if we brought an action for delivery up, that would involve a submission to the jurisdiction of the court for the purposes of that action. There might be a debate about the extent and correct meaning of section 2, 6, a submission in respect of proceedings extends to an appeal, but not to any counterclaim, unless it arises out of the same legal relationship or facts of the claim. So our submission would not generally be a submission in respect of a counterclaim, but there would be an argument about whether the salvage claim asserted by my learned friend arose out of the same relationship or facts as the claim. So we would say the claim is one that we are entitled to ownership of the cargo, and my learned friend would say the counterclaim is for salvage and you defeat the salvage claim by your assertion. So there would be a debate about that. So I'm afraid, my lord, the answer is no. We would not accept that we would be giving that we would be submitting to the jurisdiction for the purposes.
Even though it's your ownership, which is what exposes you to liability for the salvage.
That comes back to the lien point again, my lord. I'm only reluctant to give a firm answer in this respect. This issue may come back before the court, where that is the actual list between the parties. And obviously I'm keen to assist the court as much as possible, but we do not accept that we would be waiving immunity by commencing an action for delivery up. But we do accept, and in fact we pray and aid on this hearing, that there's clearly an argument that we would be. And that is why we would not want to bring an action delivery up, and for reasons I'll come on to develop later, nor would we need to. But as my learned friend said this morning, it would be surprising if the net effect of the provisions of the Merchant Shipping Act was that a state that was, on a proper application of the restrictive theory, entitled to immunity, if we win on this appeal, could nonetheless be forced to give up that in order to get back the cargo which was immune. And in our respectful submission, that would be a surprising outcome, because it would essentially undermine the immunity that we have under the restrictive theory. But I will be coming back to that later.
Right.
So, as I said, our submission is in outline that the judge misconstrued the Act and the restrictive theory. But as I said this morning, even if he is right as to the use of the silver in 1942, that it was commercial, he was wrong to take that into account when considering the position in 2017, because any commercial obligations had been discharged in 1942. It's a matter of record that the freight had been paid and the purchase price had been paid. So that those commercial...
The voyage wasn't completed.
My lady, the voyage wasn't completed, but that was because the maritime venture had come onto an end, and I'll be coming back to this in due course in relation to abandonment. But as I say, my learned friend accepts paragraph 46 of his skeleton, that to make good his his claim in salvage, he needs to be able to identify the maritime venture. And the maritime venture, insofar as it was commercial and would have given him a way around the immunity, had long since come to an end. Exactly as my lady said, the voyage came to an end, the ship and the cargo was sunk. Or, to use the phrase of Lord Diplock in Alcom, which is tab 10 of the original authorities bundle, the silver wasn't earmarked for commercial use. And insofar as it was earmarked for commercial use in 1942, which we dispute, it certainly was not earmarked for commercial use in 2017. And the use in 1942 was, again, to quote Mr. Justice Stanley Burton in AIC, weak evidence of a present intention as to its use. And so that brings me on, which is why I said I was going to have the general introduction to what we say is the first issue arising out of the new issues, which is the question of whether Section 10.4 applies to wreck at all. It's perhaps not surprising that my learned friend and I have identified the questions posed by the court in slightly different language, but we say the first question is whether, on its true construction, the Act applies at all, or whether it's confined to situations when the maritime adventure is still on foot. And I think that was the phrase my Lord Justice Popplewell used last time. So I'll be coming on later to whether the receiver of wreck has power to determine salvage. And my learned friend's second question, whether immunity could be prayed in aid to obtain release. Strictly speaking, we would suggest that in fact the issue we identify, that does the section apply to wreck at all, comes first, which is why I'll deal with it first, but is the only one that directly affects the outcome of the appeal. Because if we are right on that, the appeal succeeds. Everything else is of interest, significant interest obviously to the interveners, but does not affect the outcome of the appeal. The other points, does the receiver have power to determine the amount of salvage due, if any, and are we immune from the receiver's jurisdiction and such like, only arise in the sense that if my learned friend is right, he has some kind of alternative remedy, and the extent to which that is relevant to the court. But we would submit that, strictly speaking, the question of whether Argentum has an alternative remedy is irrelevant for the reasons which the interveners set out in paragraph 7 of the skeleton argument that they've lodged. If we are immune, the court must give effect to that immunity. See, in particular, the decision in the Constitution, which, if I could ask the court to turn up, is in the supplemental bundle of authorities at tab 13. This is the case which the judge quoted in his judgment when he said it would be surprising if a state was seeking to avoid a liability to pay salvage. So it's supplemental authorities bundle, tab 13, page 146. And this case involved salvage services provided to a frigate belonging to the United States. And after the salvage services were provided, one can see from the exchange of correspondence, which is set out at page 147, but we don't need to go through. The salvor asserted a claim for £1,500. The American consul offered £200, which the salvor rejected as being entirely inadequate, and sought the issuance of a claim form in rem against the vessel. The judge declined to allow the writ to issue and instead wished to hear from the Admiralty advocate on behalf of the government and also the United States government. One sees that on the foot of page 148 and over to page 149, the representation. And if I could ask the court to go through to page 152 and 153, which is the relevant passage. So the judge is considering the applicability or otherwise, Sir Robert Phillimore, of the claim to immunity, and says at the bottom of the page, it has been alleged that great hardship will inure from the decision of the court, insomuch as it will expose foreign ships to great difficulty in future if necessity should arise for salvage services to be rendered. So the concern there is that if a state-owned ship is immune, no salvo will go to its assistance because he will never be paid. And Sir Robert goes on to say, to that I must answer that it would be improper to suppose that any foreign government would not remunerate the services of the salvos, taking proper measures to ascertain what those services were. That's the passage that the judge referred to.
Isn't that precisely what your clients are trying to do, Mr. Smith?
My lady, no. What we're trying to do is to avoid having that issue ruled upon by this court rather than a court in South Africa, or if my learned friend can get home on in personam jurisdiction, a court exercising in personam jurisdiction. I accept that we would take the time bar point in South Africa, but that comes back to my the point my lady and I debated earlier. That is a consequence of the claim form or proceedings not having been brought in South Africa in time.
But it's not an answer to the moral point that's been made in this case.
My lady, no, but the next sentence with respect is an answer. Although Sir Robert said, I have no reason to suppose that would not be the case, he goes on to say, be that as it may, I have to discharge my duty, which is to say that in the absence of precedent principle, I cannot consent that any warrant shall issue from this court. So that is the point. As I think the Master of Rolls said on the second day at the last hearing, it's a court of justice and not of merit.
Yes.
And if we are right on state immunity, that is the consequence that flows. Going back to the point in relation to 10.4, can I just helpfully, I hope, say that my learned friend starts his skeleton with some general observations about the law in relation to salvage, paragraphs 10 to 12, which we, broadly speaking, agree with, subject to one point which is important, which I've mentioned already and I will be coming back to. We do not accept that the salvage services provided to a state-owned vessel give rise to a lien. I'll come back to that in due course, but subject to that, we accept what he says of those paragraphs. And we also, I hope it assists to make clear, we accept that generally speaking, wreck, bullion in particular, can be the subject of salvage. That's his footnote 67, and he cites the Thetis, so he doesn't need to trouble the court with that. We accept that wreck and bullion can be the subject. But that is not the point, we would suggest, when considering whether state immunity can be invoked in response to a claim in rem for that claim in salvage. We also agree, and this is paragraph 64.3, and I mentioned this morning, that section 10.4a can only ever arise in the context of a claim for salvage, and that is because the only in rem claim against cargo is a claim for salvage.
Well, that's not quite true, is it? There is the other provision about droits of evidence and other matters.
My lord, yes, I'm rightly reminded, and I think I made that point at the beginning of my speech last time, but for practical purposes.
Largely, if not exclusively.
Largely.
Salvage is the whole subject matter of 10.4a. Is that the right way of putting it?
It probably is. Our submission is, as the court will be aware, that section 10.4a is of no applications to claims in rem against wreck. It is concerned with claims against cargo, that is cargo, at the time when the cause of action arose. The court has already looked at section 10.4a, but if we could turn it up again for these purposes, please. Authorities tab on page 5. State is not immune as respects an action in rem against a cargo belonging to that state if both the cargo and the ship carrying it were, at the time the cause of action arose, in use or intended for use for commercial purposes. So the section is clearly, as the Master of the Rolls observed at the last hearing, drafted in the present tense. In our respectful submission, it presupposes that a cargo is being carried at the time that the cause of action accrued. And Article 25 of the Salvage Convention essentially has the same timing point in it, which is that it looks at and considers the moment at which the cause of action accrued, or in the language of Article 25, it is at the time of the salvage operations, which may in fact be very slightly different, but materially the same. So one is concerned to look at the state of the cargo in 2017, and the reason for that is one is looking at state immunity as a response to a claim by the salvor, which arose in 2017, not in 1942. As I said, it is common ground that any maritime venture is required to ground the claim for salvage. But if the ship and the cargo have been sunk and abandoned so as to become wrecked, then the common venture is at an end. And in that respect, if I could ask the court please to have, again, the decision of Mr. Justice Sheen in the Lusitania, which is the supplemental authorities bundle at tab 21. And if I could ask the court to look, please, at page 315. I'm going to use the bundle numbering rather than the report numbering. It's page 388 of the report. So, picking up just above the letter F, Mr. MacDonald found in his argument that Lusitania was not derelict on the speeches in Bradley and Newsom. And as my lords are aware, that's the case, my lords and my ladies are aware, that is the case that I referred to this morning, where the warning shots were fired and that the ship was not sunk. And Mr. Justice Sheen sets that out. In that case, the defendant's ship, Jupiter, while on a voyage from Archangel to Hull, was attacked by an enemy submarine. Crew were compelled to leave the ship, and he sets out the facts of Newsom. But then over the page, if I could ask the court to look at letter C, applying the same reasoning to the facts of this case, i.e. Lusitania, there can be no doubt that when the master and crew and passengers abandoned Lusitania, they did so in order to save their own lives and without any hope of returning to her, hope or intention of returning to her. If I had any doubt about that, the state of mind of those who abandoned the ship shortly after she sank, the matter would put beyond doubt by the fact that the Cunard Steamship Co. claimed it and were paid by the underwriters on the basis of an actual total loss of the ship. The owners had abandoned their ship. So far as the owners of the contents are concerned, there's a necessary inference from the agreed facts and from the lapse of 67 years before any attempt was made to salve the contents that the owners of the contents had abandoned their property. We say that is precisely analogous with the facts of this case. The ship was abandoned after she was struck by, I think, the second Japanese torpedo in 1942. A claim on the insurance was subsequently made. She was at that time insured under the British government's wartime insurance scheme, which is why the hull is now the property of the UK government. But a claim was made on the insurance. The silver, my clients, as the court is aware, or two members of the court are aware, and if I can say that my clients purchased a replacement. It wasn't insured, and we purchased a replacement cargo immediately afterwards, which was delivered in 1943. Again, insofar as the cargo would be treated separately to the vessel, it's a necessary inference from the agreed facts in the lapse of 67 years, longer I suspect in our case, before any attempt was made to sell the contents, that the owners had likewise abandoned their property.
But is Mr. Justice Sheen there dealing with abandonment for the purposes of wreck, or is he dealing with abandonment for the purposes of property? Because as I understand it in this case, this was a dispute as to who owned the property between the salvors as finders and the Crown. And insofar as that related to things that were on the vessel, that turned upon the vessel. The chattels, which were the contents of the wreck, had belonged to the passengers. That's what's being here addressed by Mr. Justice Sheen in terms of abandonment. And is he talking here about whether those passengers' chattels are wreck, or is he talking about whether they don't have an interest in the property because they've been there for 67 years and they've abandoned them as a matter of property, which is not the same question.
The former, my lord, one sees that from, which is why I started at paragraph at page 315, letter F. This is dealing with Mr. MacDonald's argument that contents were not derelict.
Yes.
And one also sees it from the result. And in that respect, if I could ask my lord to look at the head note, because the basis upon which title went to the salvors is that in the absence of the true owners, and it's easiest to find that in the head note of page 3112. So having rejected the Crown's claim, Mr. Justice Sheen held that in the absence of the true owners, there was no better claim to the contents than the salvors had.
Well,
so it's finding
317 letter D, it's quite clear, isn't it? The contents are wrecked for the purposes of Part 9 of the Merchant Shipping Act.
My lady, I'm grateful to it. There are a number of references, and I say the outcome.
That's the consequence.
That is the consequence.
Finally.
So, but I was trying to address my lord's point about whether this also affected the title, and the answer is no, because
this is wreck.
This is wreck, and what dealt with the title was the absence of the true owners.
And it's wreck as derelict by reference to the intention of the cargo owners, not by reference to the intentions of the ship owner.
My lord, I think abandonment of the ship is a necessary precursor to abandonment of the cargo.
I think the two went hand in hand.
But the two go hand in hand in this case. But
they wouldn't necessarily always do so.
They wouldn't necessarily always do so.
You may have an unsalvageable vessel with a very salvageable cargo.
One indeed, or one may have wreck that is washed up on the shore, which is some of the wreck that is referred to in the provisions of the Merchant Shipping Act that we'll be looking at later. So not always, but in this case, yes. Our submission is that the analysis in the Lusitania is analogous to the facts in this case, and more closely analogous than in Bradley.
Sorry to interrupt you again, but I think in answer to the point my lord made, one looks at 316 between D and E. Mr. Justice Sheen looks at the position of the ship by reference to what the owner's intention was in relation to the ship, and then looks at the intention of the owners of the contents immediately after. Yeah. The owners had abandoned their ship. So far as the owners of the contents are concerned, it's a necessary inference from the facts, etc., that the owners of the contents have abandoned their property. So you could have a situation where the owners of the ship have abandoned it as wreck, but the owners of the property have not abandoned their property because they haven't given up hope of getting it back.
My lady, yes, in which case the contents would not be wreck.
Yeah.
But for the purposes, or for one of the purposes of one of the submissions I should be making, which, as the court is already aware, focuses on the abandonment of the maritime venture. The abandonment of the venture by the owners would still be relevant. Owners of the ship would still be relevant.
So salvageable cargo in a vessel that has sunk may not be. It's not wreck.
Or may not be.
Or may not be.
May not be. Depending on.
It's difficult to impute to the cargo owners that there's no hope of recovery, which seems to be the test. No intention and hope of recovery, which seems to be the test for derelict.
I think
if it's salvageable.
One of the points that Sir Nigel Teare put in argument at first instance, from recollection, and I may be doing him a disservice and not getting this entirely accurately, was what if you had a ship that was run aground and beyond economic repair, and therefore was going to be abandoned by the vessel owners and certainly abandoned to the underwriters as a constructive total loss, but nonetheless the cargo was still capable of being salved. Yes. And we would say that illustrates the point entirely, that at that stage the venture, in terms of the ability to salve the cargo before it becomes wreck and abandoned, is ongoing. So the salvors in that context step into essentially the shoes of the owners.
You've lost me completely.
Why is the venture?
I'm sorry, you've lost me.
You can't continue with the ship.
You can't continue with the ship. It's never, the cargo is never going to be carried any further. The goods are not being carried in the vessel anymore, and the cargo is not wrecked.
My lord, I apologise. I've put the matter entirely the wrong way round, and then I got on. I apologise. in that situation, you have the ship. She is wreck if she is abandoned, particularly if she's abandoned to her underwriter. The cargo may not be wreck in that sense, but what I had intended to say, and I apologise, is that the ship nonetheless is wreck. The ship owner, for example, if the salvor bought the cargo to destination, would not be able to claim freight unless the freight was already due. And therefore the venture is at an end and abandoned, and that would be the point that the cargo owners sought to run in Bradley. So it is common ground for present purposes that the cargo is wreck. That's clear from a learned friend skeleton argument. I appreciate, of course, that isn't binding on the court, but in our respectful submission, it's common ground and correct that the cargo is wreck.
And you say that is so because the inference from it being left there as in the Lusitania for 75 plus years is that your clients intended to abandon it.
And from the fact that my client's predecessors in title, the Union government, immediately replaced it, and from the fact that in 1942 it would have been, we would suggest, inconceivable to anybody that there might be any prospect of recovering it. The next point that I would make in relation to this part of our submissions is that English law clearly recognises, certainly for the purposes of the Merchant Shipping Act, a clear distinction between cargo and wreck. And if I could just ask my lord and my ladies to have divide a 9 of the Supplemental Authorities bundle, which is the Merchant Shipping Act, 1995.
Just before you do so, where's this taking you? Because I think your last submission was that the relevant distinction isn't between cargo and wreck. You can have cargo which isn't wreck. What matters is the ending of the commercial maritime adventure. So I think you're saying we don't construe the Act by drawing a distinction between cargo and wreck. You can have cargo that isn't wreck, but that's what takes it out essentially of the removal of immunity because it's no longer being carried.
My lord, the headline submission is that the section, so section 10.4, does not apply to property that has become wreck rather than is still cargo. And part of the reason for that, part of the reasoning behind that, is that on it becoming wreck, the maritime venture, which was the original commercial venture that justified removing immunity, has come to an end. And in that respect, I was going to show the court one or two sections of the Merchant Shipping Act where cargo and wreck are dealt with differently and recognised as being, certainly for the purposes of salvage, different. And perhaps I'll just take the court to one, which is at page 71, which we'll look at again later, section 226. The provisions in relation to the salving of cargo are set out in 2261A, and the provisions in respect to the salving of wreck are set out in section 2261B. And subsequent sections of the Act deal with the powers of the receiver of wreck in relation to salvage operations relating to cargo. Clearly in the context that the purpose of those provisions is to try and prevent the cargo becoming wreck. So one sees, for example, at section 233, that for the purposes of, amongst other things, preservation of shipwrecked persons or of the vessel, cargo and equipment, the receiver has certain powers to require people to provide assistance and such like. So the emphasis of these sections appears to be that services may be provided by the receiver or by a salving in respect of cargo with a view to prevent it becoming wrecked.
Ditto a vessel.
Ditto a vessel. So in our submission, section 10.4 does not apply at all when the claim in rem is brought against wreck, not cargo, not least to come back to the very beginning again, because the property, whether one calls it wreck or cargo, is no longer being carried by the ship. And if section 10.4 is limited in that way, then in our submission on the facts of this case, the claim to immunity must succeed because the silver was wreck, not cargo. Tilawa was wreck, not a ship. And Tilawa was therefore no longer carrying the silver at the time the cause of action accrued.
But your submission is, I understand the way you shimmied into it, but your submission is essentially, looking at the construction of the section, is that it doesn't apply to cargoes which are not being carried. And because wreck is a cargo which isn't being carried, it doesn't apply to wrecks. But cargoes which are not being carried, I think in your submission, is not limited to wrecks. You can have cargoes which are no longer being carried, which are not wreck. Salvageable cargoes from wrecked vessels.
They could be intended to be carried for a commercial venture, though.
The reason why 10.4 would still be 10.4a would still be inapplicable in those circumstances, because one would still have to look at the ship.
You're fading again.
Sorry, the reason 10.4a would still be inapplicable in those circumstances is because one would still have to look at the ship and consider whether she was in use for commercial purposes.
Well, I understand that. We're looking at, I think, three different aspects of 10.4a at the moment. One is what you get out of the fact that you're talking about a cargo. The second is what you get out of the fact that it has to be a cargo being carried. And then we also have to look at whether it's being carried in a ship which is in or intended for commercial use. But at the moment, I think you were just weaving a bit between, on the one hand, cargo, and on the one hand, being carried. And you were suggesting that you've got a benefit out of the distinction in the Merchant Shipping Act between cargo on the one hand and wreck on the other.
My Lord, it is perhaps three strings to the same bow, if I can put it that way. Firstly, there is a distinction between cargo and wreck, and this property is wreck. Secondly, there is a requirement to be carried.
Just to be a pedant about it, there's a distinction between cargo which is not wreck and cargo which is.
My lady, that...
Because cargo which is wreck is cargo which has been abandoned or amounts to derelict, but not all wreck is cargo. So it's cargo which is not wreck and cargo which is wreck.
My lady, I see the point. In many ways, that leads into my alternative.
Well, but I thought your submission was, once it becomes derelict, it's not properly described as cargo at all. It's only described as wreck, and that's why you see the distinction in the Merchant Shipping Act between cargo on the one hand and wreck on the other. I had thought that was your submission.
I should perhaps have said cargo that has become wreck. Yeah. When the one could still say it is cargo that has become wreck or is simply wreck for the purposes of these submissions. Doesn't matter. So the submission...
Well, it matters to this extent, that you if that's right, you don't get anything out of the use of the word cargo on its own.
Well,
do you?
But,
I had thought your submission was, just look at cargo. This is your first strand. Just look at the fact that it says cargo. Wreck is not cargo, and therefore it doesn't apply to wreck. But you're not saying that.
what I am saying is it does not apply to cargo that has become wreck.
And that is because it's no longer being carried, or because cargo which has become wreck isn't within the expression cargo.
Because the section refers to cargo rather than cargo that has become wreck, but also because it's no longer being carried, and also because if it's become wreck, it's neither in use nor intended for use for any purpose.
Well, I understand that. I'm just trying to tease out the three strands or the three strings you say you've got to your bow, and I'm still on the first one, which is how much you get out of the word cargo. And I'm still having a bit of difficulty here. How much, indeed, if anything, you get out of the word cargo, if cargo can include cargo which, if something that is a wreck can properly be described as cargo which has become wreck.
Can I put the matter this way? If it were only the use of the word cargo, I could see that I would be in some difficulty, because something that was cargo became wreck, it could still be argued to be cargo. Linguistically, I would still say that cargo still connotes something that is being carried, even without the words being carried on, because that's what a cargo is. It's something being carried on a ship or some other mode of transport. But I accept that by itself, cargo is probably the weakest of my three strings. But read in conjunction with the requirement for being carried and to have some use or intended use, the combined effect of the 3 points is to take cargo that has become wreck outside the ambit of the section.
So coming to your second string, have I got your submission right that it ceases to be carried once the maritime adventure has come to an end?
It is not being carried in the present tense sense that the Master of the Rolls suggested on day 2 of the previous hearing.
Well, in some ways it wouldn't really matter whether it was derelict or not for those purposes, because the minute that the adventure stops, so back to Mr. Justice Teare and the sandbank, the moment the ship runs aground and is declared as a constructive total loss, it may be on a reef which makes it jolly difficult for anybody to get to it, so you need salvage services to get it off. And the owners may not have actually decided to get rid of it or to abandon it, but the venture's come to an end. For all practical purposes, it's no longer being carried anywhere because it's stuck aground.
While it was stuck aground and the owners had not yet abandoned the voyage, the venture would still be on foot, because there was the possibility of a successful salvage or refloat and carrying on to destination. That's
suppose the hypothesis is the example is of a vessel which is not commercially salvageable, as it were. It's a wreck in the sense of the owners not intending to perform any further function, and therefore not to carry the goods any further to their destination. If the goods are going to be carried any further, it'll have to be by some other method. But the goods are valuable and salvageable and sitting there in the vessel on the sandbank. I think that's the factual hypothesis.
I'm sorry, I had misunderstood. I thought
that was Mr. Justice.
I thought that was Mr. Justice Teare's example in his judgment.
Yeah, I had thought my lady was putting a slightly different example to me, where the owners had not yet formed the intention to abandon. I apologise.
But
if the owners have settled on the intention to abandon the voyage, then the adventure is at an end, and there is no carrying going on in any meaningful sense, because there is no transportation or prospect of transportation of the cargo on the ship which the commercial venture relates to.
So the ship may be wreck, the cargo isn't wreck, but it's still not possible for 10.4 to cover it.
By cover it, you mean to remove the immunity?
That is your case.
Yes. I can't show from that. That is the consequence of my submission.
And that would apply even if one was in a situation where immunity would not attach if it were a claim, for example, by the owner of the ship for damage caused to the cargo. There was a claim against the state for breach of the contract of carriage in some way, putting a dangerous cargo on board the ship or something like that.
There, subject to my Lord Justice Popplewell's point about the Brussels Convention, we would be into Section 3,
yes,
and we have lost immunity because
yes,
of Section 3 and susceptible to an in personam claim.
yeah. But you say not an in rem claim.
Because there would be no maritime lien, so there's no,
Yeah.
if we're looking at English law, there's no claim in rem in any event.
Yeah.
So in that situation, no immunity, but not because of the inapplicability of Section 10.4, but because of the direct claim. But
It's a bit odd, isn't it? You've got a vessel, and if it is just worth salvaging the vessel and the cargo's on it, then no immunity. But if it isn't worth salvaging the vessel and the cargo's on it, then there is immunity. When that's got nothing to do with any sovereign use of the cargo, or anything other to do with any sovereign functions of the state cargo owner.
Well, it also means that it depends upon entirely upon the intentions of a third party, namely the ship owner. Because it all turns on whether or not the ship owner decides he's going to abandon the vessel or not.
before I go on to deal with that, I'm going to deal with that. Can I simply make the point that I understand the reason for testing these points, but that is not our case. But I understand that it is a consequence of my submissions that might be the case on another day. If it were to be said that granting immunity in that situation was disproportionate, then that might give rise to issues. For example, whether there needed to be a declaration of incompatibility and so forth, and therefore whether the court needed to have representations from the government in relation to that. That isn't our case. But if it were, our submission would be as I made this morning. And there is always going to be a time limit or an intention limit that brings to an end the situation that would have allowed immunity or would not have allowed immunity. And what I mean by that is this. My learned friend used in his skeleton, he uses the phrase in a trice. So I'll use that phrase. He says, in a trice you suddenly become immune. And I can't shirk from the fact that that is a consequence of our submissions. But that is because the analysis, as I put to the court this morning, is that the draftsman of the Act has drafted Section 10.4 and the immunity that is allowed or taken away as it is by 10.4 depends upon there being a maritime venture. And that is defined by reference to whether the ship is in use for commercial purposes or not. And, or to put it alternatively, if it is still a merchant ship, recognised to be a merchant ship capable of resuming the voyage. And I accept, as my lady has said, that might, in certain circumstances, turn on the particular views of the owner when faced with a casualty. Do I abandon or do I try and carry on? So I see the submission that would be made against me were I trying to justify that immunity. But I'm not asking for that immunity because we're only looking at the cargo. But I appreciate why the court needs to take it into account. But our submission would be that you are still identifiably looking at the commercial or otherwise nature of the venture that the parties are engaged in. And if an state owner of cargo is engaged in a commercial venture, having its cargo carried on the merchant vessel, that is the trigger for 10.4 applying at all. It's a two-stage trigger for in personam, you just look at the ship, for in rem you have to look at the cargo as well. And either when that submission comes to be considered, if it ever has to be, that's a good submission. and therefore I don't fall foul that immunity is not disproportionate, or it's a bad submission. But with respect, it's not a submission the court has to finally rule on in the context of this hearing.
The problem that is bothering me is why it should be the trigger when it wouldn't be the trigger under international norms. So what you have is a situation where, as I understand it, under the wider international conventions, sovereign immunity very much depends on the use to which state is putting whatever it is that they've got, whether it's the ship or the cargo on the ship. And there's a broad carve out for commercial uses. And you have a situation where, let's say hypothetically, both the ship and you've got a merchant venture and you've got cargo on board the ship for a merchant venture, and on the face of it you wouldn't expect immunity to attach to that, and just because of the happenstance of a casualty, suddenly state immunity attaches, and that strikes me as rather odd. It may be the consequence of the draftsman, but I find it very strange. I can't actually at the moment see what the justification for it is, conceptually.
My lady, the state immunity only attaches in respect of claims that post-date the change in circumstances. And that's the only justification I can give. So there would be no state immunity, for example,
for a claim that predated it.
Where the cause of action predated it, and in particular, no state immunity, for example, not on the facts of this case, because in fact we bought the cargo from the state of India, so in fact there still would be under Section 3, but assume we bought the cargo from a commercial dealer in silver, there would be no state immunity in relation to that, because that was a live obligation still, where there were performance still to be carried out by both parties, and certainly by my clients. And then you would be into Lord Bridges' analysis in Premier Congreso del Partido, whether the claim to immunity was being asserted in response to the enforcement of a private law obligation. So there would be immunity in that respect, my lady. I'm not suggesting that immunity would suddenly disappear. But what there wouldn't be, sorry, there would not be immunity in that sense. I'm not suggesting that the immunity would suddenly reappear, but that there would be immunity in respect of subsequent claims that arise at a time when the original commercial transaction, the original commercial venture, has come to an end. Yes, it happens in a trice, or however one wants to put it. But that doesn't necessarily make it a demerit that one can say, well, this side of the line, yes, this side of the line, no. And one tests the matter the other way round to look at the position of the salvor, or I'll avoid keep saying alleged salvor, but the court is aware that there's issues about that. They have performed a service, yes, but without our knowledge and not at our request. And it's a unique service, as my learned friend says, that only in maritime context gives rise to an award under the Salvage Convention. And my lady has said, well, we've looked at all the other conventions. The most pertinent is, of course, the Salvage Convention, which looks at the time that the services are provided and says, are you entitled to immunity at that time? And our submission is, yes, if we are not then engaged in a live, ongoing...
Well, the answer is in virtually every case, because the commercial venture will almost always have been frustrated.
Well, in every case of wreck salvage, I accept that, my lady, but not in every case of other salvage.
No.
And not, for example, in the case of contractual salvage, which is the example of the Altair. Can I move on to our alternative ground? Because I'm not sure that I can provide any further assistance. And because the alternative ground does, in one sense, grapple with some of the points that the court is raising. Our submission is that if we're right on additional ground A, that is to say that this section simply does not apply to cargo that has become wreck. I'll use that phrase because it is more accurate than it can be. Then that is an end of the appeal. and that it properly reflects the restrictive theory, and particularly if one is looking at wreck, I should have said before I moved on to ground B, that is consistent with the cases on bank accounts, albeit I accept in an enforcement context, but the cases about dormant bank accounts, which we looked at on the previous hearing. And it is also consistent with the approach of Lord Clark in Savas, which focuses not on where the asset came from, but what is being done with it at the time. And my learned friend says that wreck, if we're right, has been excluded from the scope of section 10.4a sub silentio. That's 64.3 of his skeleton. But our submission is it's in fact been excluded by the express requirement for there to be a cargo that is being carried. But as I said, we recognise that construed in this way, it might be said that that immunity was disproportionate. And particularly, to pick up on my latest point, if you have got a cargo that, although it has become wreck, may well be salvable, such that the owner may form an intention in relation to it. And if that is a concern, our respectful submission, this is our ground B in our amendment notice, is that insofar as the correct construction of the section is that it does not apply to cargo that has become wreck, we would say that the court can construe it so it does apply to cargo that has become wreck but has been salved. So essentially it's become cargo again. And of course, I should preface this part of my submissions by saying it is not our case that the immunity we contend for is disproportionate. But if and insofar as my own friend says it is disproportionate, then in our submission that can be put right by construing the section so that cargo includes wreck that has been salved and become cargo again.
How can it become cargo again if it's not carried
Or
anywhere?
it is treated as cargo for the purposes of the section. So this is my Lord Justice Popplewell's point about how far the simple naming of cargo rather than wreck gets me.
This is only potentially the alternative to the first string of your bow.
Exactly.
You still say you retain your immunity because it's not being carried in the present and the ship's not in use in the present for commercial purposes.
Exactly, my lord. So it goes no further than saying that if the nomenclature is the weakness in my point, I still succeed because of the not being carried and not in use. And so exactly that was the point I was going to go on to make. If one construes the section so that it applies to a wreck that has been salved, we are still immune because Tilawa is still wreck, because the ship was not in use or intended for use at the time the cause of action arose. Because the
So what's the point then in construing the section as applying to cargo that's been salved? It doesn't get over the disproportionality.
If the disproportionality is related to the ship, I accept that. If the disproportionality is because it's a carve out of all wreck, it does. Insofar as it's carved out simply because it's wreck rather than because it's not being carried anymore. But they are, all of these submissions, in one sense, simple language points. Either as a matter of construction, looking at the section, the court is with me, but there needs to be some carrying. Let me rest simply on that, for both my first additional ground and my alternative additional ground, that there needs to be some carrying in the present sense at the time of the salvage operations. And that is sufficient for our purposes. The court is not with me as a matter of language, and I can't make that any better by repeating it. And unless I can insist further on our alternative grounds A and B, I would like to move on, if I may, to deal with the question of whether the receiver of rec can determine salvage. In our submission, the answer is that the receiver of rec does not have power or jurisdiction to determine salvage. The receiver is appointed by the Secretary of State under Section 248, and my Lords, I'm just in response to my Lord Justice Popplewell's request that we should identify where we see the sections in the old Act and the new. Both teams have prepared a document. I'm going to ask if I may hand up ours. We've not yet had the chance to look at each other's and see if we can agree them, but Maloney Jr. has prepared a ready reckoner of which sections in the 1894 Act became which sections in the 1995 Act.
Well, that's very helpful. It would be more helpful if it were agreed, but it's probably sensible.
But over the lunch and adjournment, I'm afraid that wasn't possible, but I'm sure it will be agreed by tomorrow. But if I can hand up the draft as it stands, in the hope that it will help.
Thank you.
Well, thank you to Ms. Hart for doing that job so quickly.
And I think both sets of juniors have done. So as we go through the section, I hope that this will help. So in Divider 9, the Merchant Shipping Act 1995, for the moment, the receiver is appointed pursuant to section 248, which provides that the Secretary of State shall have general superintendence throughout the United Kingdom for all matters related to rates. The Secretary of State may, with the consent of the Treasury, appoint one or more person to be the receiver of rate for the purposes of this part. And the receiver shall discharge such functions as are assigned to him by the Secretary of State. As my learned friend has said this morning, the receiver is given certain specific powers by the provisions of the 1995 Act, which largely reflect powers that the receiver was given under the 1897 Act. But the one thing that is noticeable by its absence is no express power to determine salvage, except in the case of unclaimed rate found in the United Kingdom, where that power is given to the Secretary of State.
Sorry to be slow. So have I understood from the schedule that there wasn't any equivalent of Section 248 in the 1894 Act?
I'm hesitant to say for certain no, but I believe not. There must have been somewhere in the 1894 Act a power to appoint. Perhaps Mr. Popplewell Juniors have got that, the tick for that box that we haven't got in ours, but we will check, but not that we've found so far. Or perhaps I should say, not that is within sections that are copied in the authorities bundle at the moment. It may be that we need to look further in the Act.
Can I just make a sort of general request about the 1995 Act and the 1894 Act? I'd find it really helpful to have a copy of the long title and also the table of contents. So without that, anyone needs to copy all the sections. It would be really useful to know what provisions there were in each Act.
I'm sure that is done overnight. I'm told 566 is the equivalent. It is indeed. Board of Trade shall have general superintendence throughout the United Kingdom. So I apologise for that.
Thank you. No, thank you.
And so, as I say, perhaps the most important point is that there is no express grant of authority to the receiver of rate.
Except for.
except for in the limited circumstances which doesn't apply. The receiver of rent is, however, given express authority to detain property. That's section 226. And the equivalent of 226 was 552 in the old Act. But only in the circumstances specified. We'll come back to those later as to whether the receiver can detain the property. The receiver is given specific jurisdiction in section 227 to sell detained property, but only in certain circumstances. And in particular, looking at 2272, the power of sale arises where the amount is not disputed. And we would respectfully suggest that means not disputed between the salvor and the owner. And payment of the amount due is not made within 20 days after the amount is due. So the owner admits salvage but refuses to pay. The receiver can sell. Or where the amount is disputed, no appeal lies from the first court to which the dispute is referred. So section 2272b presupposes that the dispute is referred to court. As my learned friend said, that is surprising if the receiver has power to determine the amount of salvage due or whether salvage is due. When I say when I refer to determine salvage, I'm referring both compendiously to whether it's due at all and if so, how much.
Also presupposes that the court's got jurisdiction to deal with it.
Indeed, I'm coming on to address that point in a moment. And then 2272c, where the amount is disputed and an appeal lies from the decision of the first court to some other court, and within 20 days of the decision of the first court. So what you have is a structure there that gives the receiver power in certain circumstances to sell.
It doesn't exclude arbitration though, does it? It can't exclusively, no. You can't read into this that this necessarily means that the only person who has the power to determine it is a judge, because the parties could still be in dispute but agree to refer the matter to an arbitrator. And the arbitrator's decision could be binding, and that could then give rise to the receiver doing various things as a result.
Indeed, and we would say that would potentially engage 2272A, where there had been a binding award by the receiver.
Because the amount is no longer disputed.
But the receiver then also has the power in certain circumstances to apportion salvage when the amount has been determined. And again, where the aggregate amount of salvage payable in respect of salvage services has been finally determined, and I take my lady's point, that could be in arbitration or in court, and therefore, I take the point, it could be by the receiver. And a dispute arises as to the apportionment. Then the receiver has powers to apportion, and under subsection 4, the receiver shall with all convenient speed distribute the amount. And just to pick up on a point debated this morning, the receiver in that context does have to make his decision in accordance with Article 13 of the Salvage Convention. That's subsection 5. So, but again, a power is being given to the receiver to apportion salvage in certain circumstances, and a direction is being given to the receiver as to how he should do so. And section 229 then goes on to provide that in other cases the court will carry out the apportionment. And the equivalent of section 229, sorry, I should have said the equivalent of 228 is 555, and the equivalent of section 229 is 556. But could I ask the court in that respect to turn back, and this may meet part of my Lady Justice Andrews' point, to section 555 of the 1897 Act at page 20 of the Act. because Section 555 is slightly different, where the aggregate amount of salvage payable in respect of salvage services rendered in the United Kingdom has been finally determined, either summarily in the manner provided by this Act or by agreement. So summarily in the manner provided by this Act is therefore subject to the financial limits that required a summary determination under the 1894 Act. Or by agreement, and does not exceed £200 if a dispute arises as to apportionment thereof among several claimants, and this provides for the person liable to pay the amount to the receiver, and the receiver then to carry out an apportionment. And then where the aggregate, over the page, section 556, where the aggregate amount of salvage payable in respect of salvage services rendered in the United Kingdom has been finally ascertained and exceeds £200. And again, that's finally ascertained, but no reference to summary determination. The assumption seems to be that that will be determined by the court.
Because the court will be carrying out the apportionment, you mean?
My lady answer.
Because the court will be carrying out the apportionment.
Indeed. And if the amount involved was sufficient to mandate that the apportionment is carried out by the court,
well,
it would be...
is that necessarily so? Because it could be finally ascertained by an arbitrator, but it could be for a sum in excess of £200. Except the arbitration agreement might also confer upon the arbitrator the power of apportionment, but it might not have done.
My lady, exactly. But the point is this, in our submission, that the Act, both the 1894 Act and the 1995 Act, distinguish between lower amounts of salvage, which the receiver can apportion, and higher amounts of salvage, which have to go to court, unless they've been done by agreement. So that could be arbitration. And it would be surprising in our submission if the receiver had jurisdiction to determine the amount of salvage where it was going to exceed £200. So if the receiver has jurisdiction to determine salvage, there's no financial limit on it. So if my learned friend's case is right, the receiver can determine a claim for salvage in any amount, but expressly by statute does not have jurisdiction to apportion salvage where the amount is above £200. That, in our respectful submission, strongly suggests that the Act is applying or is granting limited and, in fact, very limited powers to the receiver.
For the purposes of the retention decision in section 239, apportionment's not relevant, is it?
No.
It's if he's got power, he or she's got power to determine for the purposes of the retention decision, it doesn't matter what thereafter happens in relation to apportionment.
Apportionment presupposes that there has been a determination and that the money is then, in the circumstances where the receiver has jurisdiction, the money is paid to the receiver, who then hands it out to the salvors.
It's a second stage.
But there would be no detention because, by definition, the salvage would have been paid. So if one looks at (555), the salvage is paid to the receiver, and he then pays it out to the parties with the claim. So the salvage has been paid. There's no detention. But the general position in respect to the procedure under the 1897 Act was set out at section 547. And if I can ask the court to look at that, page 16. There is no equivalent to this section in the 1995 Act. And this is the one respect in which we part company slightly with my learned friend's submissions, because he says that there does not need to be an equivalent of this because by the 1995 Act we had the Salvage Convention. Our respectful suggestion is that the reason this provision is not repeated in 1995 is because it is not necessary, because the Supreme Court Act or the Administration of Justice Act followed by the Supreme Court had given salvage jurisdiction to the Admiralty Court, and the County Courts Act had given salvage jurisdiction to the county courts. So that's where I'm going with this point. But under section 547, disputes as to the amount of salvage, whether of life or property, and whether rendered within or without the United Kingdom, arising between the salvor and the owners, cargo, alcohol, wreck, shall, if not settled by agreement, arbitration or otherwise, be determined summarily in the manner below. So there's a summary jurisdiction for low-value claims, and everything else under subsection 2 goes to the High Court. So save as aforesaid, disputes as salvage shall be determined by the High Court. Now, that is subsequently, we would suggest, reflected in the provisions of the Administration of Justice Act, which is why we put that in at divided 3, which gives jurisdiction to the High Court in relation to claims in the nature of salvage. That's page 31. That became the Supreme Court Act at page 44, referring to disputes in the nature of salvage.
Is there anything in the Travo for the Administration of Justice Act that says that this particular provision replaces section 5471?
Not that I've been able to locate, my lady. The reason for the submission was simply to meet Dr. Strader's point, that he suggested that the reason this section did not reappear is because it didn't need to because of the Salvage Convention. Our submission was that the more likely explanation is it doesn't need to for this reason. But perhaps also importantly, if one goes to tab 8, one sees the jurisdiction of the Admiralty County Courts. At section 27(1)(f), any claim in the nature of salvage. But then going on to subsection 2, that jurisdiction is limited to those claims where the property does not exceed £15,000 or the amount of the claim does not exceed £5,000. So essentially, the summary determination under section 547 becomes the Admiralty jurisdiction of the County Court in due course, and the remaining jurisdiction becomes the jurisdiction of the High Court. My Lord Justice Popplewell asked the question as to what did or otherwise mean in that section. I accept that conceptually it could mean the receiver. But in the context of a section or a part of the Act which is dealing with the powers of the receiver, it would be surprising in our submission if the section did not say, or by the receiver, if that is what it meant. That is the first submission. The second submission is that if or otherwise means the receiver, then the receiver only had jurisdiction up to the summary level, because section 2 is subject, as aforesaid, all disputes shall be determined in the High Court. So this is dealing with summary determination.
Sorry, does subject as aforesaid mean that you've got those that are settled by agreement and arbitration? Let's just leave it there for the moment. They're not getting into the court system at all.
Sorry, my Lord.
Subsection 2 doesn't apply to those at all, does it?
My Lord, no.
And equally, it doesn't apply to those that are settled otherwise, whatever that may mean.
I see the point. The better point I should have gone to make is that that would, in our submission, be a reference to any other jurisdictions or courts with power to determine salvage. And we can copy and make available, but certainly my understanding is that at least the courts of Admiralty of the Cinque Ports had, and indeed still have, jurisdiction in very limited circumstances to determine matters of salvage. So in answer to my Lord's point about what could the or otherwise mean, and I think we have got, if it helps, a copy of the
of course, the Cinque Ports actually have powers to determine salvage in certain types of case.
Indeed, my lady. Very, very limited cases, and I don't think it take. I can hand up copies if necessary, but I don't think it takes the matter any further, and certainly I'll let my learned friend have copies. But that was an example that occurred to me over the luncheon adjournment of what might be otherwise.
Well, it gives content to otherwise, which doesn't mean it must apply to the receiver, which I'm not sure that Dr. Straker had managed to find for us.
My lord, yes.
For my part, I am interested in seeing that.
My lord, in which case we've got this. Is that my lord, yes, and cross and across, and this is as it is now, so subject to repeals and such like.
Well, I suppose just taking that one stage further, conceptually, if there was another court that had an in personam jurisdiction, let's say that an in rem action's been brought here, but there's another court with an in personam jurisdiction, and you get there first, and there isn't a lis alibi or some kind of attempt to prevent that other court from going ahead, and it decides the matter in a way that's binding on the parties, I suppose conceptually it could be settled by another route that way. I haven't thought that through, but by some other court which has jurisdiction, you say Cinque Ports, well, it may well be that there may be some other court that could do it.
But agreeing to the jurisdiction of that other court would engage questions of submission under the Act, and that would probably be the answer there. But I don't want to spend too long on
We're not just concerned with immunity here. We're looking at
we're just looking at general.
We're looking at powers generally.
But my lord raised the question of what otherwise might be, and in the luncheon adjournment it occurred to me that the courts of admiralty of the Cinque Ports, with a very limited salvage jurisdiction, might be an example of something.
Which section of this do we need to look at? I'm not suggesting you take us to it now, but we'll.
My lord, I have rather carelessly handed round all of my copies. Section 1 provides that it shall be lawful for the Lord Warden to appoint, nominate and appoint by any instrument, essentially persons to hear, and it's the fourth line, to adjust and determine any difference relative to salvage which may arise between the master of any vessel and the person or persons bringing such cables and anchors by extremity of weather or by any other accident whatsoever, and leave the same in the roadstead. And my lord, one can read on. It's a fairly arcane and limited power to determine salvage.
Right, thank you.
And my lord, to follow up from one point, my lord was mentioning this morning about the receiver wreck. Entirely coincidentally, the present judge of the Cinque Ports is Sir Nigel. So, my lord, what we do say is that we have here, subject to anybody else falling within the words otherwise, we have here a comprehensive system that is saying what the receiver has power to, and where the receiver is not giving power, in our respect, does not have that power. And that point is made good in particular, because if the receiver had a general power to determine salvage, there would be no need to give the Secretary of State or the receiver acting on his behalf, if the Secretary of State asked him to do so, the power to determine salvage in case of unclaimed wreck found in UK waters. That specific power given would be entirely OTO's if the receiver already had that jurisdiction. And so we say that tells very strongly against any suggestion that the receiver has that jurisdiction generally. And following on from that, we would ask the court to compare and contrast, as it were, the position in relation to a wreck commissioner. A wreck commissioner is appointed by the Lord Chancellor pursuant to section 297, which the court will find page 99 of the bundle. And that section specifically provides for the Lord Chancellor to appoint such persons.
Sorry, you're ahead of me. Give me the page again.
Page 99 of the bundle, section 297.
Thank you.
So a REC commissioner is appointed by the Lord Chancellor rather than the Secretary of State for a term of office that is defined in section 297, subsection 2. And the REC commissioner is then given certain specific powers. For example, at section 268, page 93 of the bundle, to conduct a formal investigation into marine accidents. And so section 268 provides for the Secretary of State to cause a formal investigation to be held. And if it's in England rather than in Scotland, it's by a REC commissioner. And subsection 2 provides the REC commissioner shall conduct it in accordance with the rules under section 271. So there are formal rules for the carrying out of the formal investigation. And subsections 3 now, subsections 1, 3 and 4 and section 97 of the Magistrates' Court Act, which provide for the attendance of witnesses and production of evidence, shall apply in relation to a formal investigation. So there are detailed provisions here about how the function allocated specifically to the receiver of REC will be performed.
So section 270, subsection 1, the power to make rules, which is conferred presumably on the Lord Chancellor. I don't think we've got it in the bundle.
I don't have section 270 to hand, but that is...
Well, that seems the natural influence. It's not. I don't think it's in the bundle.
Can I revert on that
Sure.
point? My recollection from memory, the last time I looked at the rules, is they're actually made by statutory instrument.
Yeah, but somebody has to make the statutory instrument.
Indeed, but not the REC commissioner.
No. My question was: does it confer a power to make rules on the Lord Chancellor, which is what one would infer from the fact that it's the Lord Chancellor who appoints? But I don't think it much matters.
Indeed. So there are formal rules for the carrying out of this investigation. There are powers to compel evidence equivalent to those of a magistrate. And at section 269, page 96, there are formal provisions for appeals from the findings of the REC commissioner to another investigation to be carried out, presumably by a different REC commissioner. Or, section 269, for there to be a rehearing in the High Court.
Well, that's all very interesting, but REC commissioners are performing completely different functions. They're an investigatory tribunal.
With the power, for example, to suspend seafarers' certificates and such like. Yes, but the point is that where this Act, where the 1995 Act, is granting powers to persons appointed to hold a, just use the phrase for the moment, quasi-judicial office, I'll come back to that, but an office. Those powers are set out in terms with provisions for appeal, with provisions for evidence taking, and with provisions for rules. Whereas, if the receiver of REC has jurisdiction in relation to the determination of salvage, there is nothing in the Act that defines how he is to exercise that jurisdiction, in contrast to the requirement that he apportions salvage in accordance with the Convention. There is nothing in the Act that deals with appeals. As my learned friend said, there would have to be a judicial review, and different factors would apply. There is nothing in the Act about the taking of evidence, about whether there would have to be a hearing, or about representation. These are all matters that no doubt if the REC Commissioner, if the Secretary of State appointed Sir Nigel, he could make essentially some kind of de facto procedural ruling as to how it was to be dealt with. But it is surprising in our submission, if the Act intended to confer this power and jurisdiction on the receiver of wreck, that we don't see equivalence in the Act to the sections we see dealing with the Wreck Commission.
Well, it doesn't say anything about how he's to go about determining ownership. Yeah, it's clear that he does have to do that himself. I'm not quite sure how far this point goes.
Because that power is expressly given to him.
Yeah, but you're making a different point, which is because there's no guidance in the Act about what procedure is to be adopted in making the determination, and because it's a quasi-judicial determination, as you say, that's a factor against the power being there. But equally, determination of ownership is a quasi-judicial function, if it is so to the same extent, and there's nothing to identify the procedure involved in that case.
And I see the force of the point so far as it goes, my lord. And for example, in this case, at one stage, the possibility of a judicial review of the decision on ownership was postulated.
Just remind me what happened to that.
I think I would have to leave that to my learned friend, because it was his clients that were suggesting there might be a judicial review, yes. And the most I can say is it went no further, and it got to the time where we would have argued that they were out of time for bringing a judicial review, and where it ended up is that it is now common ground that we are the owners, so it's perhaps a moot point. But certainly at one stage it was suggested that the decision of the receiver of wreck would be the subject of an application for permission.
And was it ever suggested that the decision of the receiver not to determine the amount of salvage might be the subject of a judicial review or not? I can see some shaking of heads on the other side.
The answer is no.
No, thank you.
I thought the answer was no, but I was not so familiar with it.
Thank you.
And just to conclude this point on the power or not, as we say, to determine salvage, the matters set out in the appendix to my learned friend's skeleton argument, where he says that there would be no immunity in relation to a determination by the receiver.
Sorry, just on that last point, paragraph 4 of the judgment records that on the 17th of April 2020, the receiver advised the claimant to the RSA she had no legal power to decide the amount of salvage, and if not agreed, salvage would need to be determined by a court. So that decision wasn't challenged, is that right?
It has not been challenged, no.
Right. I'm afraid the history is much more complicated than there appears. The receiver then agreed to revisit her decision, right. And the matter then meandered on for a while until such time as the matter was resolved by agreement, and so there was never a final determination by the receiver of reg in relation to ownership. I stand open to correction from those behind me. I was not involved.
This is about ownership.
We're not on ownership now.
This is about the amount of salvage, and if not agreed. So sorry, paragraph 4 of the judgment deals with what appears to have been some correspondence between the claimant and the defendant about whether or not the receiver had power to decide the amount of the salvage if it wasn't agreed. And her view, expressed according to the judgment in the letter of 17th of April 2020, was that she didn't have power to do that.
Yes, I think that the best way for me to deal with this is not on the hoof. I was not involved in the case at that time at all. And if it's a question that I will take instructions and be advised by those behind me. And I'm sorry if I stood up. My answer, no, still stands.
So, certainly my understanding is that the receiver's, I'm not going to say decision, but her indication that she had no power to determine salvage has never been challenged.
Right. I seem to remember that on the last occasion when my Lord Justice Popplewell raised the hair of the receiver of rec, we were shown some of the correspondence on this, and the flavour I got was that there was no final determination one way or the other, but the basic information was that the receiver of rec didn't think she had the power to deal with it, and it was all a matter for the court.
My recollection of the correspondence I've seen more recently is that the salvor says you do have the power to determine it, but we quite understand that you might think it's all much too complicated and difficult for you.
Yes.
And the upshot was that the receiver said that she thought it was a matter that was best dealt with by the Admiralty Court proceedings, which by then had been commenced.
Yes.
But anyway, you'll give us chapter and verse on that.
And while we've been considering that, the answer to the point my lady raised is that under section 270, the Secretary of State may make rules for the conduct of formal investigation.
It's the Secretary of State. Thank you very much.
The thanks are due to Ms. Hart. And so I was going to refer briefly to the appendix to Malone and Friends' skeleton argument, where he sets out the arguments for why we would not be immune to the jurisdiction of the receiver to determine salvage if the receiver has that jurisdiction. And the headline point to make in relation to that is that that simply reinforces in our submission the point that the receiver cannot therefore have jurisdiction. It would be surprising, to put it at its lowest, if we had immunity from the adjudicative jurisdiction of this court, yet somehow the receiver, a person appointed by the Secretary of State, could make exactly the same determination, having detained the cargo pursuant to section 226, without us being able to invoke jurisdiction.
Does that depend on your submission that there would still be immunity if a claim were brought by the owner? If it be the case, which I know you don't concede, if it be the case that if a claim were brought by you qua owner to recover the cargo, and in those proceedings you would be susceptible to a determination of salvage made by the salvor against you because of section 2. If that is the effect of section 2, I know you don't concede that, but if that were the effect, would it be surprising that if the receiver is exercising the ownership rights and determining for the benefit of the owner whether the cargo should be released upon payment of salvage, that the same immunity regime should apply, i.e. you don't have immunity in either situation?
Well, the surprising would be an additional submission why we are right on the other point, my lord, because it would still be surprising that a state that was, on the proper application of the restrictive theory, immune from the jurisdiction of this court, should somehow be brought back within the jurisdiction by the happenstance that the salvor brought the cargo to this jurisdiction and availed itself of the provisions of the Merchant Shipping Act.
Well, that's only because the owners want to get their cargo back. If they didn't, we wouldn't be in this situation. There wouldn't be a claim for salvage against them at all. But the owners want to get their cargo back, and it's been detained by the receiver of wreck. If the owners were bringing a claim in court to get it back, then, although you don't concede this, section 2 might well have the effect that there was no immunity from the salvage claim. Why is it surprising if the same were the case, if there's a detention by the receiver of wreck and the owners are trying to get their cargo back, and they can only get it back from the receiver if they pay the salvage, whereas if they're in court proceedings, they could only get it back from the receiver if they paid salvage?
Because the net effect of either of those formulations is that, despite being a sovereign state entitled to immunity under recognised principles of English law, the state was, in the end, not immune in respect of the claim, and that is why it would be surprising. It would be removing the immunity that we were otherwise entitled to.
But as a result of your assertion of ownership, which if you asserted it in court, would not give you immunity.
Well, we have asserted it in court, my lord. We've asserted it in this court by acknowledging issue of the claim form in rem and saying that we wish to assert our rights in the property. We're not asking for an order for delivery up, but we are within
Well, that's
wrong time.
that depends on the rather limited extent to which one comes within Section 2. If you're only entering acknowledgement of service in order to contest jurisdiction, so I'm not sure that helps you very much, does it?
Well, it's not just to contest jurisdiction. Subsection 4 of Section 2 provides subsection 3b, which is the submission section. It may help have it up at page 2. Does not
just give me a moment. Yes.
So we are not deemed to have submitted if we have intervened for the purposes of claiming immunity or asserting an interest in property in circumstances such that the state would have been entitled to immunity if proceedings had been brought against it. And when we acknowledged issue of the claim form in rem, there was a dispute as to ownership. And so part of our application was that the grounds of our application were that we were the owners, which we needed to establish in order to then assert immunity from the claim in rem. So, my lord, intervening in the proceedings to assert
were you not able to say, if we're owners, we're immune, and if we're not owners, we're obviously not liable? The court didn't need to determine ownership in order to determine the question of immunity.
It did, because we have to establish that we are the owners of the cargo to establish immunity, because we are the state asserting immunity.
But aren't you just asserting an interest in property? Under 4b, circumstance that you would have been entitled to immunity.
Indeed.
The proceedings have been brought against you, because the proceedings are brought in rem, so they're brought against the thing,
Indeed.
not against you.
Indeed.
So you're saying we got an interest in property in circumstances that we would have been entitled to immunity if we'd been sued rather than the thing.
Indeed. And then claiming the immunity that goes with that.
Yes.
And
so 4b applies. So you're not deemed to have submitted to the jurisdiction for those purposes, are you?
Indeed. That was the point I was making. That is the purpose for which we've intervened in this action, and we are not deemed for those purposes. So I think my lord made the point that if we were asserting our interest in property, we would have to submit to the jurisdiction. And my point was not correct with respect. Because
if you asserted in a claim, you would, or you don't concede that, but
if we assert it in response to a claim,
no, in a claim. In a claim. If you asserted it in a claim, but if you assert it by way of defence to a claim, then you're entitled to such immunity as you would have to such claim.
Indeed.
That's all that. So
and
that's all it amounts to, isn't it?
And that would be deprived of all effect if the eventual outcome were to be that because the cargo had been declared to the receiver of wreck, well, bought here and declared to the receiver of wreck, we ceased to be immune in respect of a claim that we were otherwise immune in respect.
Well, I don't take too long on this, but the difference is that as far as the receiver is concerned, you're making a claim to have it released to you. The whole point we're on at the moment is, can the receiver determine salvage as a condition of releasing it to you? And releasing it to you involves you asserting, by way of a claim, an entitlement to it, because you're owners, doesn't it?
My lord, yes. If I need to bring proceedings, this is presupposing that if I satisfy the receiver that I am the owner, in accordance with the Act, the receiver then says, is salvage due, and forms a view on that. And we dispute the suggestion that it's incumbent on us to bring proceedings for delivery up. Because
I understand that. Yeah. I was just addressing your point that it would be very surprising if you weren't able to use immunity as a complete answer to the salvor's claim in salvage if it were determined by the receiver when you would if the claim for salvage were brought in court. And I'm simply drawing to your attention that there is a similarity in the situation in which you would hypothetically be claiming ownership in court, and in which you are, in this case, claiming ownership in order to secure release from the receiver. That's I think, as far as the point goes.
But the hypothetical, again, only arises because of the fact that the receiver has got the cargo.
Yes.
So it still comes down to the same point, which is that I would be immune from a claim in rep. But because the cargo has been delivered to the receiver and detained by the receiver, and I have to get it back from the receiver, that the ultimate outcome of that is that I end up losing my immunity one way or another.
Well, it would be the same if it hadn't been given to the receiver and the salvors were holding onto it themselves.
That would depend on where they were holding onto themselves.
Yes.
And I'm not sure that is right, because we would need to give some thought to that. That would depend on where they were.
I understand your point.
My Lord, I've gone slightly off point, and I apologise. I'm also conscious of the time that I've massively overrunning. But if I can move on, the simple point I was going to make is that in my learned friend's appendix, he lists a number of reasons why he says that we would not be immune from a determination by the receiver of rec. One of which is to point to Schedule 14 of the Constitutional Reform Act, and he makes the point that we are not one of the listed judicial office holders in Schedule 14. If we could just turn up the Act, which is at Divider 10 of the Supplemental Authorities Bundle. While we have it open, just to make a submission that probably comes into tomorrow, but I'll make it while we have it open. My learned friend's reliance on this Act is a little misplaced, because it's only dealing with disciplinary powers. We see that from Section 104. So Schedule 14 is the schedule of lists office holders who can be subject to disciplinary powers by the Lord Chancellor. That's Section 108. And then Section 109 then says that this section has effect for the purposes of Section 108, and then provides that judicial office are the office holders listed at Schedule 14. So my learned friend says this is a comprehensive list of judicial office holders, and the receiver of recs not on it. But the point to draw your attention to is that page 127, the Rec Commissioner is on the list of judicial office holders. So the Rec Commissioner is performing a function that recognisably brings it within it, for example, the ambit of the Lord Chancellor's disciplinary powers. The receiver of Rec is not. So, as I say, our submission is that the receiver of Rec has no express power to determine salvage. It would be inappropriate to imply a power. I recognise that raises the question of why Mr. Aikins, as he then was, told Mr. Justice Sheen in the Lusitania that salvors normally recover 50%. I think this probably was the outcome of the debate about that this morning, but in our submission that is a reference back to the power as it then was in Section 525 to determine, for the Board of Trade to determine salvage due in respect of wreck discovered within the jurisdiction, but not claimed. But there is another and perhaps more fundamental point, which is this. Undoubtedly, the Admiralty Court has jurisdiction to determine salvage. And when county courts had jurisdiction in Admiralty matters, the Admiralty county courts would have had the limited jurisdiction in relation to salvage. Undoubtedly, where the parties choose to refer a dispute as to salvage to private arbitration, the arbitrator has salvage, but there'll be jurisdiction, but there'll be issues of waiver there in relation to sovereign immunity. But if the receiver of rec also has jurisdiction, who is to determine which party is the correct party to make determinations? So if the receiver concludes that no salvage is due, but the court concludes that salvage is due, which takes precedence? If the salvor is adamant that salvage is due, if a court has predetermined that, if courts determine that, there will be an issue of estoppel. But if the receiver determines no salvage due, does that bar the disgruntled salvor from having another bite of the cherry in court? Or indeed
no, it means he can, but it just means that the cargo will have been released.
In any event, yes, it means it's been released, which obviously is the outcome that we contend for at the end of the day. But again, it would be surprising in our submission if the receiver were to have an implied power to determine something that the court is given an express power to determine.
Just come back to my example of ownership. I mean, why is the position different in determination of salvage from the position in relation to ownership? For certain purposes, the receiver is given power to determine ownership. It's not a power for all purposes. It won't determine ownership if there's a probate dispute later in relation to chattels. Parties may say ownership's entirely different, but it will be determinative for the purposes of the particular functions for which the receiver is given power to make the determination. And the critical question is, in our case, is determination of salvage one of those powers for the particular purpose of deciding whether or not to release from detention, not for all purposes and binding all people for all time, but for the purposes of that function, which is a statutory function which the receiver is bound to perform. That's the point.
Indeed. And first point, if I can just tick off a point I was going to come back to in relation to that, and the extent to which the receiver has combined the parties. Our submission is that the receiver's decision would be binding as between, on ownership, as between the salvor or alleged salvor and the owner, but not on, or the party claiming ownership, but not on any third party who sought to prove a better claim. That's the reserve in the power. So,
why would that be so? If it is a public law power to make a determination for a public law function, then that's the full extent of its scope. That doesn't give rise to an issue of estoppel, does it? Even between the parties who have an interest in that question.
Sorry, I was addressing a different point. Binding on the party, subject to the possibility of a judicial review.
Well, even without a judicial review, never mind judicial review, doesn't bind the parties in any other aspect of a dispute between them.
I should perhaps have focused on the point I was really getting at, which is that, as Dr. Straker said, the rights of third parties are not affected by this decision, and that's specifically
Well, obviously not.
No, obviously not.
But in relation to determination as to ownership, that is not, or we would suggest, a claim in the nature of salvage. That's a claim in relation to the ownership of the property. And therefore there is no overlap with the salvage jurisdiction of the High Court there. Whereas if the receiver has jurisdiction to determine salvage, there is a complete overlap.
Well, the High Court has the power to determine ownership.
If we bought, yes, but not for the purposes of Section 239, because that for the specific purpose of the obligation to release arising.
Right. That's the very point I think that my lord is making, which is he may have a power with the receiver which may be for a limited statutory purpose, which doesn't overlap with the power of the court.
In which case, I can do no better than come back to saying, if there were, it would be set out the same as it is in Section 239, and the point would not get any better for making it here. I'm conscious of the time.
Yes, that's a convenient moment
that is.
for you to break. At some stage, I'd just like to be clear, and you can deal with this tomorrow if you'd like, what you say to my Lady Justice Elisabeth Lang's inquiry as to section 22 of the State Immunity Act, and whether you are saying that if the receiver does have power to determine the amount of salvage for the purposes of section 239, it would be acting as a body exercising judicial functions, and for that reason you would be able to claim immunity in relation to that question.
My Lord, that was the next one point I was going to deal with. The answer is yes, we would be able to invoke immunity and ask question. I will develop that briefly tomorrow.
Right, thank you very much. 10:30.